Hi everyone and welcome to Family Law Assistance and happy Wednesday. Yay, we're halfway through the week. Let's keep it going. I wanted to jump on here today and just quickly talk about something that we deal with on the daily. And I'm guaranteeing you when we are dealing with it on the daily, courts are dealing with it on the daily as well. So what am I on about? I'm talking of course about allegations of abuse. And one of the reasons I want to talk about this is because for a start, everybody thinks that their case is the only case that have allegations of abuse. Now, with me dealing with it on the daily and the courts dealing with it on the daily, I thought actually I'm just going to jump on and give the voice of perspective. So from where we are and from where the courts stand, every case that goes through the family courts is going to have allegations of abuse in one way, shape or form. And those allegations of abuse can range from they looked at me a bit funny all the way through to allegations of the more sinister kind. Okay. Now, if you are the person watching this and you yourself have been accused of some horrendous allegations of abuse, I get it. The court is equipped to deal with those allegations of abuse, and this is how they do it. Now, there was a piece of legislation that was beefed up a while ago, so for those of you that like a little nighttime reading, go check out Practice Direction 12J. Now, Practice Direction 12J, I was a fan and an advocate of Practice Direction 12J before it was a thing, before it got beefed up, before it was the norm in courts. Because often, not always, but often allegations of abuse, the way the courts will interpret that varies from court to court. Now, the reason I mentioned Practice Direction 12J for a little nighttime reading is because Practice Direction 12J says that if there are any allegations of abuse, that they need to be investigated ASAP, like from the get-go. Now, if you're a dad, and I'm saying dad specifically, okay, mainly because often, not always, but often, they're the person that tends to be on the receiving end of allegations of abuse. Not always, okay, so I appreciate that for the majority I'm broad stroking. If you are that person, okay, what you may have received is either something called a Scott schedule or a C1A form. You will have had in one way, shape or form a list of allegations, and that list of allegations may either have come to you via a C1A, a Scott schedule, social services, or even CAFCAS, okay. Either way, it's what your ex is saying about you. And in some cases, it may be that the allegations of abuse is stopping you or is being used as a bar to prevent you from having a relationship with your children. Practice Direction 12J really talks about having that get-go, having those allegations dealt with at the get-go. Now, why am I a fan of it? I have been from a fan of it. Now, mainly because it gets the idea of allegations. Those allegations, whatever they may be, whether they are ranging from the, well, he looked at me a bit funny, all the way through to something very sinister, having those allegations dealt with from the get-go means that whatever happens at the end of that investigation about those allegations, there is a line drawn underneath it. Okay. Now, the reason I say that, why that's important, way back when, before they beefed up Practice Direction 12J, what you'd find is that the allegations of abuse would constantly be used as a bar for progressing contact with children. And what tended to happen was that there would never kind of be a resolution. Now, don't get me wrong, the idea of finding a fact has always been in the court's remit, but not quite so formalised as it is today. So in practice, that just meant that if you were on the receiving end of allegations of the, well, he looked at me a bit funny kind, okay, then often that would be a preventative from you having a meaningful relationship with your children. Practice Direction 12J, and I'm going to talk about that in a second, but Practice Direction 12J gets rid of that. It gets rid of we deal with the allegations, we deal with it, and whatever happens, we move on from it. And you can see the logic in that. Now, I'm going to talk specifically about what happens. Like, you look at it and going, yeah, what's she talking about? So Practice Direction 12J, like I said, was a piece of legislation that was beefed up quite a while ago to take into account allegations of abuse. Now, spoiler alert, every application that goes through family law will have allegations of abuse. Okay, so I understand how you might feel like, oh my gosh, she said all these horrible things about me. She's created me out to be this kind of monster. I get it. But you're not alone, because every case is going to be this. Every case is going through very, very similar to you. Okay, so let's just get that out of the way. Okay, and I say that because I'm being the voice of perspective. It's often a very lonely and stressful and horrendous experience going through this. So and a lot of what you're going through may be blighted by these allegations of abuse. So what am I talking about specifically? What can the courts specifically do? Well, the big picture here is that they will deal with those allegations of abuse. They will deal with the allegations, and there's a procedure. Court is all about procedure. And one of the things that's quite frustrating is that people often say to me, oh well, courts are slow. They are, but honestly, most government bodies and organisations are slow. So when we're talking about the slowness of it, yeah, but I will say that it's a lot quicker than it used to be, which is probably not much comfort to you, but it is. So like anything that's government bodied run, there is a procedure, okay? And if Practice Direction 12J says there should be a Scott schedule, now a Scott schedule is just a posh legal way of saying there's a table, almost like a kind of spreadsheet, if you will, of allegations. And that spreadsheet is, you've got 3 columns. Column 1 is what your ex reckons about you. So there's going to be a list of allegations. Column 2 is your version of events. What happened? Okay. Now, it will be accompanied by a statement because there's not a huge amount of space in that Scott schedule to kind of elaborate on what may or may not have happened. And column C is a column for the judge. Now, don't be surprised if your ex has maybe 50, 60 allegations, okay? If your ex has got that kind of list of allegations, okay? And hey, I'm not prejudging whether what happened or not happened. Often that's very difficult sometimes to determine, and mainly that's often difficult to determine because we're working with a civil court here, and a civil court will work on a balance of probability, which is very, very different to that of a criminal court. When we're in a criminal court, the burden of proof is a lot higher. In a criminal court, you have to prove something beyond a reasonable doubt, which means that the bar for proof is up here. That makes it kind of difficult, especially when you consider that the majority of the cases are domestic abuse allegations. And often there isn't any proof for that, you know. Victims of domestic abuse don't tend to go and report things. Victims of domestic abuse don't even want to acknowledge the abuse that went on. And to that end, they may not seek medical help. They may not go to the hospital when they've sustained injuries. So, you know, but that doesn't mean to say that those things didn't happen. So I get that family law is a grey area. Allegations of abuse can be a grey area. Because of that very thing, if you were to try and prosecute that in a criminal court, you can understand why, if the burden of proof is so high, why you'd want to have that found in a civil court. But to that end, let's be really clear here. Any outcome in a civil court, unlike a criminal court, it's not a case of guilty or not guilty. It's a case of, is it more likely than not that they did X, Y, and Z? Okay, and a court can either find it in your favour or in your ex-partner's favour. Okay. Once we have a Scott schedule, the court should be calling something called a filter hearing. And that filter hearing is just what it says on the tin. It's going to filter through all the allegations. Sometimes the court may not be interested in allegations, for example, that are historic. The court, for example, may want to know what's happening more recently. The court will then call a trial. And by trial, I mean there's going to be a day. It's usually a day. Sometimes it's 3 or 4 hours, but even if it is 3 or 4 hours, it's a day at least, okay? It's a day at least. Where the court is going to hear evidence and is going to read the evidence, whatever evidence that there is. And both parties get an opportunity, whether represented or not, to cross-examine each other. Now, there have been a lot of difficulties just in that area and arena alone because, well, let's be honest, if you're the victim of domestic abuse and you are representing yourself, are you actually going to want to cross-examine the alleged perpetrator of abuse? The courts have got a way around this, actually, and if you are using somebody like us to assist you, the courts can either grant someone like me rights of audience, or what's often more helpful is that when we help put together questions, that the judge will read them out on your behalf. Now, if you're on the flip side of this, okay, and you are somebody that's been accused of these allegations, and sometimes they may be horrendous allegations, okay, it is your opportunity to be able to question your ex. Now, the courts, it's difficult. Most of the time, both parties representing themselves, which kind of makes it tough, especially when we're dealing with allegations of abuse. And I'm putting all of those allegations of abuse under one bracket, right from they looked at me a bit funny, right through to the more sinister stuff. Either way, there is that opportunity, and the court will want to read and hear any evidence. And at the end of that trial, the court will make a determination as to whether or not, and this is important, whether or not it is more likely than not that this happened. And that's important because, like I said, it's very different to criminal court. Now, what does that mean in relation to having a relationship with your children? Well, like I said, way before practice direction 12J got beefed up, I was a massive advocate of it. And I was a massive advocate of it because of the fact that it drew a line, rightly or wrongly, for whatever was to happen, it drew a line under the issues that were preventing contact, under the issues that were a bar for contact. And whatever happens, whatever needs to happen, whether one party needs to go on courses, or whether they found in their favour, it doesn't matter. It just draws that line underneath it. Now, big picture, of course, dealing with allegations of abuse is going to cause a delay. Of course it is. And actually, overall, possibly that delay is going to be around 3 to 6 months. Now, the reason I sound blasé about it, well, I've been doing this for a heck of a long time. Good God, it must be nearly 13 years. So I've been dealing with this for a long, long time. So when people come to me and go, oh my God, 3 to 6 months? Yeah. But, and here's the big but. Overall, trust me when I tell you that without it, having that relationship with your children is going to take 10 times longer. So I'm just trying to think of the phrase. Is it short-term win for long-term gain? Whatever. You know what I'm trying to say. It's all the words. So that's my point. The point is that, yeah, you're right. You know, it's going to create a delay, and it's very frustrating that you're having to deal with this when really all you want is just to have a relationship with your children. I get that. But overall, it's in your children's best interests that happens, so that we can put that to bed. Whatever's going to happen is going to happen. We can put that to one side then, and then move on to have a relationship with your children. A lot of people kind of say to me, is it right? Is it fair? The whole idea of being fair, and the whole idea of justice. Well, honestly, the other thing that people often say to me is it biased? I get that a lot. Now, from somebody that's really impartial, I'll be honest, I've helped men and women, both sides of this camp. I assist people that are fighting to have a relationship with their children or who are on the receiving end of allegations, but I also help the flip side of that when there have been allegations, and I'm assisting on that as well. So I see both sides of this fence. And honestly, is it fair? Is it just? I think my honest answer has to say is that it's difficult. It's really difficult, because you are in front of either magistrates, so 3 people, or a bunch of people that don't know you. You're in front of a judge that doesn't know you. Often these allegations are without evidence. I mean, I know sometimes we have things like if a victim has gone to the doctors, or they've sustained injuries, but you know, look, the idea is that a lot of the time those things happen without a lot of evidence. So it is very difficult, and when you've got somebody that doesn't know you from Adam, they have to go on what's in front of them. It's one of the reasons actually why I don't judge. I can't, in my job, judge. And a lot of people who are trying to defend allegations of abuse often will say to me, or try and convince me, that they're innocent. And I tell them this: listen, I'm probably doing a better job if I don't believe you, because I will be asking those questions that the court will be asking. That's what makes me so good at my job. Is it right? Is it fair? Probably not. You know, I mean, the legislation that's afforded to the courts and to you is a decent piece of legislation. I think, and I'm probably getting slightly off topic, but I'm addressing it because people do say these things to me. People do ask my opinion for this, and I've got to say that is it right? Is it fair? I think people often miss. I always say that the rules that we play with in court are not the same rules that we play with in reality, and I think it's understanding those rules. And heck, that's why people use people like me. There's a song, I think it was Dolly Parton, somebody correct me in the comments, you know, but there's a song, and the song was, "It's not what you do, it's the way that you do it." And that is so true, because often in court, when we're dealing with allegations of abuse, if words were like currency, then you want to make sure that you're spending that currency wisely. So often what happens is that in these pre-hearings, certainly the person that's defending those allegations of abuse, in reality tends to want to tell the judge war and peace and completely loses sight of there's a procedure there. Yeah. And I think that's where the mismatch happens, because you've got a court system who runs on procedure. Okay, it's a government organised body. It's a procedure. We do this, we do this first, that next, and the other. But on the other hand, you've got somebody who's defending those allegations of abuse. And so for them, every time they go to court, they feel compelled to give the court war and peace at every point. And often that's not helpful, and often that can be quite damaging to their case, because actually what the person here needs to do is to step back and understand that this is just a procedure. I mean, listen, this is why people use people like us. And sometimes I think the court needs to understand that, hang on, this person is being accused of some horrendous things. It may very well be a procedure just for them, but you know, this is these people's lives. So I understand where that mismatch comes in. I honestly believe that there needs to be 2 strands, and you know, it's something that one of the reasons certainly up here at Family Law Assistance I'm a massive advocate of, because this is not just about procedure. I can sit here and talk to you about Practice Direction 12J. I can talk to you about Practice Direction 27A and talk to you about bundles and how to present a bundle. That's the easy bit. What's trickier is in your head, how emotionally do you deal with that? You know, you've not seen your kids for ages. You've now faced a slew of horrendous allegations. How do you deal with that? And it's one of the it's one of the reasons I come on here. It's one of the reasons that we've got our blog. It's one of the reasons we do the whole Ask Us Anything. You know, I mean, these especially now, these are really tricky times, especially when you think about the fact that there are online hearings, so you don't get, so these online hearings, they're virtual, so you don't get you don't get anything of that body language. You don't see how they're reacting. The judge doesn't see it, you don't see it, and that's difficult because you can't read the room. Family law is all about reading the room. Family law is all about demeanour, which you lose on a virtual hearing, or on a telephone hearing anyway. And here's the other thing. So the online, the virtual hearings, that's going to be the go-to for most of us for now. Okay, so it's difficult in that. So there's the pros and cons, and I do talk about this. But the pros are you won't have to wait for long for your hearing. Okay. Those of you that have been in court in person will know that the majority of the time you'd spend forever in the waiting room. You know, I know they said 11 o'clock on your court order, but if we get in before 2, we're doing well. So if you know, you know. And one of the plus sides that we've had of these telephone hearings is that generally they tend to run on time, which is yay, which people can get on with their lives. You're in the comfort of your own home. And, you know, it tends to be a much more relaxed affair rather than going to a very intimidating courtroom. And some of those buildings can seem quite ostentatious. If any of you have been to Royal Courts of Justice, you know, blimey, you know, if you're not used to that, you know, you're not used to it, it can come across as quite intimidating. Anyone that's been in a courtroom will know that, you know, if you've got the other side coming up to you, you may feel a bit bullied, you may feel intimidated. So, you know, so the plus side of that is that that's taken away at the moment because we've got all these virtual hearings. The downside is, of course, is that you don't get that pre-court negotiation. If you've got assistants or someone like me, you tend to miss out a little bit on, quite honestly, vital talks between the other sides. So you miss out on that, and you're missing out, of course, on reading the room. So on that note, I'm going to leave it there. Okay, I could honestly rabbit on forever. Let me know in the comments down below what experiences you've had. Okay, I'll say this always, but if you need any assistance, do shout and holler. I'm also going to give a shout out actually to as you may or may not know, family law assistance is going through a massive change at the moment. It's huge. Okay, there's a lot of moving parts, and I'm excited to be announcing more and more things. So what I can be saying is that we have a new website being launched this week. That will give so it's much more cohesive. All of you guys out there who are looking for help, there's all of our blogs, all of our articles are in one place, so you can just kind of have a shift through that and just have a general reading. Also, if you have been wondering what to do with your life now that COVID has struck, and you're either on furlough or you may be thinking, now's the time for a change of career. And if you have the empathy and drive, determination, and honestly, the skin of a rhinoceros, then you may want to start a career with family law assistance. We are currently looking for people to join our family. I'm super excited to be introducing you to some of our graduates at the moment. You'll be getting to see those a lot more, but if this is you and you feel like you've got something to offer the world, and let's make no mistake, what we do can be life-changing. So if that's you and you fancy doing something of a change of a career, and you want to join, you either want to learn to do what I do, or you want to learn to do what I do and join family law assistance family, get in touch, shout and holler at me. Anyway guys, I'll leave it there for now. Hope you have a great day. Bye.